So, ang papag-usapan po natin today is yung most recent petition po for interim release ni FPRRD which she filed nung June 12, 2025 po. So, ano po yan, tiniming talaga nila sa Independence Day. So anyway, kung makikita po natin dito, kinover agad to ng mga international news outlet, hindi lang po ng local news natin, ng Reuters, France 24. So pang international po talaga si PRRD. Anyway, for today po, explain ko kung ano ba talaga yung interim release, tapos i-discuss ko rin po mismo yung petition na final nila. And then magbibigay na lang din po ako ng personal assessment ko kung whether or not ano ba yung chances, mas mataas ba yung chance kung mag-grant ba to or ma-deny po yung petition. Okay, so good day everybody. This is AttorNEIL Abayon po, your quote-unquote favorite TDS lawyer. Pero before po tayo mag-start, just a quick reminder lang po sa inyong lahat. Kung nasa YouTube po kayo nanonood, huwag niyo po sana kalimutan mag-subscribe kung mag-enjoy kayo sa video na to or in any of my past videos. At kung nasa Facebook naman po, follow naman po yung gawin ninyo. And kung masyado pong mabilis yung pagsalita ko or yung pag-discuss ko, tandaan po natin, pwede po yan pabagalan by clicking the cogwheel po, tas adjust nyo na lang yung playback speed. Lalo na po kung nasa YouTube kayo nanonood, pwede nyo po yan i-adjust talaga. And lastly po, tandaan natin, wag po tayo maghalo-halo ng issues. Kung ano po yung pinag-usapan natin dito, kung ano po yung facts and issues at yung batas na pinag-usapan sa video na to, yun lang po yung pag-usapan natin. Wag po tayo maghalo-halo, wag po tayo magdagdag bawas sa statements ko. Okay? Ngayon start na po tayo sa discussion. So, una-una po muna explain ko kung ano ba talaga yung interim release. Quick refresher lang po. Na-explain ko na ito sa past videos ko but just a quick refresher lang kasi baka nakalimutan nyo na po eh. Okay? So, yung interim release po, basically this is equivalent or somewhat equivalent po to the right to bail po natin dito sa bansa po natin under our constitution. So, basically po, during the pendency of a case sa ICC, so dito po sa case ni PRRD, nasa pre-trial pa lang po sila. So, pwede po siya mag-apply nung tinatawag na interim release at ang purpose po niyan is para makalaya siya pending nung case po niya during the pendency of his case. So, kaya po siya somewhat similar sa bail kasi same po yung objective nila para palayain po ang akusado during the pendency of the case. Okay? The only difference lang po, yung interim release under the Rome Statute, hindi po siya matter of right. So, hindi po porket nag-apply yung isang akusado sa Rome Statute or sa ICC is automatic papalabasin agad siya ng korte. Meron po yung specific grounds, specific requirements para payagan po siya ng korte. So, in that sense po, pwede natin sabihin na discretionary lang po yung interim release sa Rome Statute po. Okay? So okay, so ngayon preliminary matters po muna tayo. So of course, this is a document submitted by the defense, specifically by Attorney Kaufman dun sa pre-trial chamber po nila pinadala. So kung gusto nyo po makita or makakuha ng copy nito, punta lang po kayo sa ICC website tapos search nyo lang po dun yung pangalan ni FPRRD, type nyo lang po yung Duterte, tapos tingnan nyo po sa court records, yung pinaka-latest po, pwede nyo po i-download to mismo yung itong binabasa kong document. Pero wala po itong mga highlights ko. These highlights are my personal highlights po, okay? So anyway, i-verify lang po muna natin na legitimate to. So of course, you can see here, International Criminal Court, and then dated June 12, 2025. So sinakto po talaga to nila Attorney Kaufman sa Independence Day nung pag-file. And then of course, it is addressed to the three judges po. Sila Presiding Judge Motok, Judge Alapina Gansu, and then si Judge Liera, okay? Yung interesting po dito na makikita natin sa title nung pleading po na to is yung term na public redacted version of the urgent request for interim release dated 12 June 2025. So ibig sabihin po ng public redacted version, ito po yung version na binigay nila sa public kung saan meron silang mga tinanggal na mga certain words due to confidential purposes. So kung makita po ninyo, with confidential annexes A, B, and C, ex parte defense and prosecution only. Okay? And of course, yung source po nito is the defense for Mr. Rodrigo Roa Duterte kasi si Attorney Kaufman nga po yung nag-file nito and dated June 12, 2025. Okay? So again, ulitin ko lang po, this is a public redacted version, meaning merong mga secret sila na sila lang yung nakakaalam, yung mga parties to the case, yung prosecutor, yung defense, at yung judges. Okay, ngayon punta na po tayo sa substance ng discussion or ng petition po nila FPRRD. So yung introduction po dito nila Attorney Kaufman, of course, kailangan nila dyan ipakita sa court kung ano ba yung layunin ng petition. So dito sinabi talaga ni Attorney Kaufman, Mr. Rodrigo Roa Duterte respectfully requests in accordance with Article 60, Paragraph 2 of the Rome Statute na magka-interim release siya to redacted. Okay, so ito pong redacted na to, most likely ito yung target na bansa or na state member po ng Rome Statute kung saan plano nila ma-interim release or mapunta si FPRRD. Okay? And then yan, the government of, again, redacted has expressed to the defense its advance and principled agreement to receive. So kung makikita po natin, meron na talagang bansa na nagpakita ng interest na aanuhin nila, tatanggapin nila si FPRRD once ma-interim release po siya. Okay? So receive Mr. Duterte on its territory for the term of his interim release and will act in accordance with its domestic law. So itong will act in accordance with its domestic law, ibig sabihin susundin po ng receiving state yung batas nila dun sa bansa po nila in relation sa pag-release ni FPRRD, which of course carries the responsibility also kay FPRRD na sundin din yung batas nung bansang yon na tatanggap sa kanya. Okay? So in accordance with its domestic law to implement such conditions as deemed appropriate by the pre-trial chamber 1. This paragraph here, ito pong paragraph 1, shows the the good faith na may talaga willingness to comply with the conditions, not only si FPRRD but also the receiving state po na tatanggap sa kanya. Okay? Tapos ito pong paragraph 2 naman sa introduction, makikita natin inter partes discussion on interim release commenced between counsel and the chief prosecutor himself immediately after the initial appearance. Okay? So kung makita po natin, nag-usap na pala mismo si Attorney Kaufman at yung chief prosecutor right after, immediately after daw nung initial appearance. Yung initial appearance yung yung pinakaunang hearing kung saan si Attorney Medialdea pa nga po yung lawyer no ni FPRRD. And the meaning itong inter partes discussion, inter partes, is between the parties, between themselves po. So between the counsel and the chief prosecutor. Nag-usap na po pala sila ng interim release. Matagal ng panahon. Ang tagal na po yung yung initial appearance, 'di ba, ni FPRRD. Okay, so anyway, ngayon punta na po tayo sa number 3. Ito pong number 3 yung medyo maganda po to yung nangyari dito kasi kung makikita po ninyo, since then and since the chief prosecutor's leave of absence, alam naman po natin, di ba, yung chief prosecutor is undergoing investigation for misconduct. So, since nung nag-initial appearance and then since nung nag-leave din po si Prosecutor Can, the prosecution has confirmed its non-opposition to interim release to ganyan-ganyan state party on the understanding that the terms and conditions set out in Annex A to this filing would be met. Okay? So, ulitin ko lang po since the time po nung initial appearance, itong nag-usap sila, and since the time na yung chief prosecutor nag-leave of absence because of the investigation for misconduct, yung prosecution, the office of the prosecution itself has confirmed its non-opposition pa rin. Okay? In short, hindi na po mag-o-oppose talaga yung prosecution dito sa petition na to. Yan yung maganda dito po sa paragraph 3 so far. And number 4 naman po, nakalagay din dyan, prosecution also accepts that the risk factors enumerated in Article 58(1)(b) may be neutralized with adequate safeguards. So ito po kasing Article 58(1)(b), ito yung provision ng Rome Statute kung saan nagsiset po ng standards or ng guidelines kung paano ma-grant yung interim release. So ipakita ko po sa inyo ng mabilisan. So Article 58(1)(b). So yan, the arrest of the person appears necessary. So in order for a person to be granted interim release sa isang ICC case po, dapat po hindi necessary yung pag-aresto sa tao to ensure his appearance. In short, dapat hindi siya flight risk. And then, dapat din po yung accused does not obstruct or endanger the investigation or the court proceedings. Ibig sabihin po nito, hindi siya makikialam, hindi niya i-intimidate yung witnesses, hindi niya po itatamper yung mga evidence kung interim release siya. And then ito, number 3, where applicable, to prevent the person from continuing with the commission of that crime. Ito po kung merong krimen na ginagawa currently pa rin yung akusado, dapat hindi niya ituloy paggawa yun, assuming na makalaya po siya. So yun yung Article 58(1)(b) po. So dito po sa petition proper nila Attorney Kaufman, yung prosecution already accepted that the risks factors enumerated dun sa 58(1)(b), yung kakadiscuss ko lang po, may be neutralized po with adequate safeguards. So as long as may condition set, which is yun nga yung nasa Annex A, tapos let's say yung ICC chamber din po later on mag-set pa ng ng further conditions na kailangan sundin ni FPRRD, yung prosecution is of the position na as long as may ganong sufficient conditions, it will be adequate safeguards po to comply with Article 58(1)(b. Okay? And then, number 5 po, sabi nila Attorney Kaufman dyan, Mr. Duterte is not a flight risk, custody is not necessary to ensure his appearance, and good reason to believe that Mr. Duterte would not embarrass his hosts. So ito po lahat mga preliminary matters pa lang naman po to, introductory discussion pa lang, kaya hindi pa ganun ka-detailed yung sinasabi po ni Attorney Kaufman dito. And then lastly po, paragraph 6, given the nature of this request which concerns the pretrial liberty of an individual of advanced age and redacted. Ito tingin ko itong redacted dito since related sa advanced age, baka may mga health conditions din po talaga si FPRRD na ayaw lang nila ipapublic. Okay, so the defense submits that good cause is shown to reducing the time limit for a response order, for a response under court regulation, so on and so forth. So basically, itong number 6, ang point po nito, para paikliin po yung period kung saan mag-undergo, let's say, ng clarificatory questions yung court or sumagot pa yung prosecutor. In short, dapat daw may sense of urgency na ma-actionan po yung petition na to. Ito yung purpose nitong number 6. Okay? Ngayon punta na po tayo sa substance, talaga yung discussion proper na may explanation kung paano talaga dinefend or inargue to nila Attorney Kaufman with legal basis po. So, unang-una po dyan, in-explain nila Attorney Kaufman yung history nung case ni FPRRD. So, ito po, February 10, prosecution, submit. Ito po, alam naman na natin eh. So, if you want to read this para po to save time sa video na to, you can again download a copy of this ICC website. Tapos, basahin nyo na po isa-isa. Pero this one, medyo alam na po to ng taong bayan kasi ito po yung pag-arrest kay FPRRD nung pag-uwi po niya from Hong Kong eh. So, yung hindi pa po talaga natin alam or yung bago po sa ating lahat is, ito po, yan. On June 9, 2025, in the context of meetings with the defense, a privilege for which it is extremely grateful, representatives of the government of blank, again, secret pa yung government, communicated its principled agreement to receive Mr. Duterte on its territory for the term of his interim release. So, June 9, 2025 po, nag-uusap na yung si Attorney Kaufman and then yung bansa po na mag-re-receive kay FPRRD. And then, sabi rin po dito nung receiving state, to this end, the receiving state po to has indicated to the defense that if invited by the pretrial chamber to make its observations, it would do so promptly. So, ibig sabihin po nitong last sentence na to, let's say si FPRRD was already released in their custody, tapos kung kailanganin po nung ICC pretrial chamber na may representative from the receiving state na magbigay ng observations niya regarding the, yung mga pinagagawa po ni FPRRD dun sa bansa nila during the interim release, is willing naman daw yung receiving state na gawin yun. So, kung makikita po natin, there is really a showing of willingness and good faith po talaga sa receiving state to not only receive FPRRD but to also comply with court orders of the ICC court in relation to sa pag-take nila ng custody po kay FPRRD. Okay? So next po niyan ngayon, in-explain naman ni Attorney Kaufman yung applicable law to this petition niya for interim release. So unang-una dyan, Article 60, Paragraph 2 of the Rome Statute. So ang nakalagay po dyan, letter A person subject to a warrant of arrest may apply for interim release pending trial. So of course, alam naman po natin na si FPRRD ngayon is still in the pre-trial stage po sa ICC case niya, 'di ba? So he is still there is still pendency po sa kaso niya, basically is my point po. Therefore, since pending pa po yung kaso niya, he can already apply for interim release under Article 60, Paragraph 2 of the Rome Statute. Okay, so ito po yung ginamit na legal basis nila Attorney Kaufman. And then yung next po, sinabi dito ni Attorney Kaufman, a deliberation on provisional release at the ICC requires a chamber to engage in a de novo factual assessment to determine whether the Article 58(1) conditions justifying detention are met. So ibig sabihin lang po nitong sentence na to, dapat daw yung ICC chamber or dito yung pretrial chamber mag-conduct po ng assessment kung para i-determine kung yung mga binanggit ko po ba doon sa 58(1), yung flight risk and yung pag-tamper ng witness, ng evidence, pag-intimidate and pag-continue of the commission of the crime. Kung present yun, pagpalabasin si FPRRD or an accused in an ICC case, dapat po hindi siya i-grant yung interim release niya. So, yun po yung point dito. Dapat daw mag-conduct ng factual assessment para makita po ng parties kung meron ba talaga nung grounds doon under Article 58(1). And then next po, in-explain ni Attorney Kaufman doon, where a detainee does not pose a risk under Article 58.1, they must be released. So ginamit talaga niya is must. That this is not discretionary, this is not a discretionary decision, it is absolute. Even where Article 58.1b risks may exist, interim release is still appropriate where those risks can be mitigated by the imposition of certain conditions of release. This is consistent with the international human rights norm that alternatives be employed as early as possible to ensure pre-trial detention is a last resort that lasts no longer than necessary. Okay? So again, ang point po dito ni Attorney Kaufman is that pag wala daw po yung grounds dun sa Article 58.1, yung tatlo pong in-explain ko, dapat daw must be released ang isang akusado at hindi daw siya based lang sa discretion ng korte kung hindi siya absolute. So yung pinaka-point po dito ni Attorney Kaufman sa argument niyang to is that pag wala nga daw po yung 58.1 na requirements, must be released na, hindi na daw yung discretionary lang sa part ng court and that it is absolute. So stated differently po, ang pinaka-point talaga niya dito or yung gusto niya i-emphasize is that the right to interim release or interim release becomes a matter of right and not simply discretionary on the part of the court when the conditions nung tatlo sa 58.1b ay absent. Therefore, matter of right na yung interim release. Yun yung explanation niya doon. However, if you ask me, in that sense, pwede siya masabing matter of right, pero since meron pa ring guidelines na kailangan sundin and of course it is still subject to review by the court, then we can still also argue na hindi pa rin siya matter of right. It is still discretionary kasi re-reviewin pa rin po talaga ng court yung lahat ng factual findings Okay? Pero anyway, punta po tayo ngayon sa next part naman. So this one po, ang sabi naman dito is that kahit na po na merong presence nung mga risk factors sa 58.1b, pwede pa rin daw yung interim release as long as meron daw conditions na iset yung akusado or yung pretrial chamber for the release. So kung meron pong mga conditions na yon, mamimitigate po ngayon yung risk. Therefore, pwede pa rin po mag-grant daw ng interim release even in the presence of risk factors dun sa 58.1b provided there are safeguard measures via those imposition nga po of mga conditions. Okay? So yun po yung pinaka-point naman ng second sentence. And then yung next naman po dito sa paragraph 14. So ito medyo mahaba po to. Again, you can just read this. I'm just highlighting po yung mga key provisions talaga. So ang sabi po dyan, chambers at the ICC and ad hoc tribunals have been minded to grant interim release where the prosecutor does not oppose the request or where state guarantees are presented in support of the application. Okay? So kung makita po ninyo, may number dyan nakalagay, diba? 24 and 25. Ibig sabihin po niyan, may sinite talaga na legal basis sila Attorney Kaufman. So kung titingnan po ninyo, 24, yan yung Gichero decision. Tapos yung 25 naman po is yung Bemba et al. This is another case po. In short, ito pong argument ni Attorney Kaufman na ganito na pag hindi daw nag-oppose yung prosecutor sa interim release, the courts dapat daw i-grant nila yung interim release kung hindi nag-oppose yung prosecutor. So meron na pong precedent with this argument ni Attorney Kaufman. So kung meron pong precedent, that is favorable po to the person who is now petitioning or praying for this interim release. Okay? So pabor po to kay Attorney Kaufman kasi nangyari na po siya dati. So basically, ginagamit lang nila yon as basis para makakuha din po ng interim release si FPRRD. Okay? And then, ang sabi naman ni Attorney Kaufman, next dyan, applications for interim release should be adjudicated as a matter of urgency. So again, may sinite po siya na naman, number 26. So yung number 26 is the ICC Chambers Practice Manual. So in other words, meron pong precedent or meron pong batas na nagsasabi na dapat bilisan or urgent yung mga matters or yung mga petitions for interim release. Okay? So this is again favorable also for the applicant here, which is si FPRRD. Okay? So ngayon punta naman po tayo sa submissions nila Attorney Kaufman. So yung mga submissions po, ito na yung main arguments talaga nila Attorney Kaufman. Okay, so kung makita po ninyo, unang-una dyan, sinabi ni Attorney Kaufman, the burden for maintaining a suspect's detention rests on the shoulders of the prosecution. So this one is again favorable to sa applicant here kay FPRRD Since yung sabi ni Attorney Kaufman, yung burden daw is with the prosecution. Ang maganda po ngayon, 'di ba, sabi ng prosecutor dito is hindi nila to i-oppose yung petition for interim release ni FPRRD. So kung ganyan po, hindi talaga nila i-oppose, lahat po ng sasabihin dito nila Attorney Kaufman sa petition na to will not be contradicted by the prosecutor. So as long as meron pong sufficient basis, legal basis mapakita sila Attorney Kaufman sa petition na to, the court now must act on this petition alone without anything na magtatry na talunin tong mga arguments nila due to the statement of the prosecution na hindi na nila i-oppose po yung petition na to for interim release nila Attorney Kaufman. Okay? So ang sa next naman po na highlighted portion, ang sabi ni Attorney Kaufman, where this test is not satisfied, the appeals chamber has held that suspects must be released. Okay? So again, meron silang sinite na case number 27. So this case po is the Lubanga decision. Okay? So ang point niya po dito, since yung burden nga to establish na yung mga grounds dun sa 58, sa Article 58 paragraph 1B is with the prosecution, tapos hindi yun napakita ngayon ng prosecution kasi again, they will not daw oppose this. Therefore, the suspect must be released based on this case po na sinite ni Attorney Kaufman. So kung titingnan po natin, that is favorable to the accused here, which is si FPRRD po. Okay? And then next po dyan, the pretrial chamber may choose to release the individual with or without conditions. So ito po, in-explain naman na natin to, di ba, na pwede po magbigay pa ng added conditions yung pretrial chamber, yung ICC court, on top pa dun sa mga conditions or promises na sinabi ni FPRRD kung ma-interim release siya. Again, that will form as a safeguard po na hindi talaga mangyari yung kinakatakutan po ng mga parties or ng korte dun sa Article 58 paragraph 1B of the Rome Statute. Okay? And then yung next explanation po ni Attorney Kaufman is that yung nasa Annex B daw, yung mga list of terms and condition that it believes would neutralize any possible concern about interim release to blank secret na bansa. These conditions are as rigorous if not more so than those that have been offered at the ICC or accepted by the ICTY, so on and so forth, for the purpose of interim release. Okay, so kung sa Tagalog pa, ang conditions daw mismo na binigay ni FPRRD sa sarili niya na dapat niya sundin pag ma-interim release siya is mas mabigat pa daw kumpara dun sa mga ibang conditions kung kailan or kung saan ginrant ng ICC yung interim release dun sa mga ibang kaso. So kung ganyan po, makikita natin na there is really a showing of good faith on the part of FPRRD here as the accused na talagang pinahirapan niya yung sarili niya para ipakita sa ICC na magiging ano na siya. Yung simplest way for me to say it is magiging good boy na daw po si FPRRD pag i-grant yung interim release niya. Yun yung easiest way for me to explain this. So eto, maganda to. This is exciting for me na makita po to considering yun nga, it is more rigorous. So ano kaya tong mga pinramis dito nila FPRRD sa ICC para maging ano siya, quote-unquote good boy ba? Okay? So ngayon punta po tayo sa next number. So ito po ngayon, letter I, Mr. Duterte will not abscond. So ito po ina-address na isa-isa talaga nila Attorney Kaufman yung Article 58 paragraph 1B of the Rome Statute. So kung makikita po ninyo, even if the burden to establish na present yung Article 58 1B na tatlo is with the prosecution, nevertheless si Attorney Kaufman po is still explaining kung bakit wala yun siya. Kahit nga po hindi niya to trabaho, pero this is now an action on the part of the defense counsel para to strengthen his position, para to strengthen this petition for interim release po nila FPRRD. Okay, so ang nasabi po ni Attorney Kaufman, Mr. Duterte will not abscond. Okay, the risk of flight cannot be based on hypothetical. Okay, there must be concrete circumstances demonstrating that the risk of flight is particularly likely. So sa courts po kasi talaga, there must really be evidence. Depende na lang po kung anong type ng kaso, kung ano yung degree of evidence yung kailangan. Pero dapat talaga may evidence yung mga arguments or yung mga statement. Hindi po pwede siya based on hypothetical discussions lang. Kasi we have to remember, pag nasa korte na po kasi, hindi naman yan mainly for educational purposes talaga eh. Nagiging educational purposes na lang siya pag lumabas na yung decision kasi it becomes precedent for law students and for law practitioners. However, during the trial proper, hindi po ganun yung objective. Dapat talaga mapakita na may sufficient evidence para ma-establish mo yung mga allegations or claims mo. So stated differently po, hindi po dapat hypothetical lang yung mga argument natin. Dapat it is backed by concrete circumstances or evidence demonstrating that the risk of flight is particularly likely. So i-visualize i-summarize ko lang po, bigyan ko po kayo example. Ang point lang po dito is hindi pwede na sabihin mo lang, natatakbo yan si FPRRD because he is a ganyan-ganyan, so on and so forth. You have to submit and show clear evidence kung paano siya magiging flight risk. Hindi pwedeng sabihin mo lang tapos biglang magiging favorable na yung decision ng korte dun sa nag-allege na yon. Okay? So yan. And next po, sabi naman ni Attorney Kaufman dito, should Mr. Duterte be deemed a flight risk by virtue of his political network or international connections, these contacts and connections must be specifically identified. Okay? The ICC Appeals Chamber has held that the prosecution bears the burden of submitting sufficient information to establish. So again, the main point lang po dito, kung yung mga nag-argue po or nag-allege na influential si FPRRD, he has a strong political network, so on and so forth, therefore flight risk po siya, again, they have to submit concrete evidence or sufficient evidence to establish that allegation nila. Hindi po pwede na mere statements lang. Okay? Kasi tatandaan po natin, ang pinapag-usapan po kasi dito is the right to liberty po ng isang tao. Diba? So hindi po pwede na na flimsy evidence or flimsy statements na yung maging basis for the detention of an individual. Okay? And then next po, paragraph 21, the appeals chamber have similarly considered and granted provisional release on humanitarian grounds. So humanitarian grounds, ito na yung mga age ng akusado and then yung mga medical condition ng akusado. So tatandaan po natin, of course, si FPRRD is already 80 years old. So of course, that is favorable to him kasi pwede niya gamitin na argument yan dito. And then kung makita po ninyo, meron din pong citation dito sila Attorney Kaufman, number 36. So number 36, unfortunately, puro redacted yung dito. So more or less, meron na rin pong precedent or legal basis si Attorney Kaufman for this. So 35, 36, puro po redacted, unfortunately, yung argument na ginamit nila dito. Anyway po, ang sabi dito ng Attorney Kaufman, Mr. Duterte is blank as substantiated and corroborated by. So this is most likely mga health conditions po siguro to ni FPRRD. Tapos nag-submit sila niya ng evidence yan as substantiated and corroborated by. So unfortunately, yun nga, naka-secret, ayaw nila ipaalam sa atin. Okay? And then sabi po ni Attorney Kaufman next, in light of the above, it would be unreasonable to suggest that Mr. Duterte has the blank ability to abscond. Pero papaisip talaga ako kung ano kaya to. So more or less siguro yung sakit talaga to ni FPRRD. So because of the sakit daw ni FPRRD, it would be unreasonable to suggest na kaya niya tumakas considering na his health conditions. Okay, and then sabi po dito, furthermore, were he to abscond, ang mangyari po unang-una, it would embarrass his host, but as one of the most recognized political figures in the world, he would be easily found and returned to the ICC custody. So therefore, since of these two, hindi realistic na flight risk talaga considering 80 years old na siya and considering popular daw na political figure pa si FPRRD. So kung makita po nyo, di ba sa intro ko, kinover agad to ng mga international news body rin po, yung Reuters and then yung France na news website po kinover din. So masabi talaga natin he is a recognized political figure. And then of course, the appearance of FPRRD is unique, very iconic. So may kilala agad siya ng public talaga kahit na po hindi Pilipino. So mataas yung chance na hindi talaga siya magiging flight risk, plus the fact nga po na he's already 80 years old. Okay? And then paragraph 25, sabi dito, finally, Mr. Duterte's commitment to returning for trial when ordered, even in the absence of any state guarantees, carries significant weight in militating against a finding of flight risk. So kung makita po ninyo, ang ibig sabihin nito, dun po sa mga annexes kung saan nagbigay po ng conditions or promises si FPRRD para maging good boy talaga siya kung palayain siya, absence of any state guarantee is also an indication po na hindi talaga daw siya magiging flight risk. Okay? So therefore, it is amplified and the risk of flight further depreciated where state guarantees are presented in support of the application. Diba? So taken into consideration the willingness and the good faith din ng receiving state na susundin talaga yung conditions at magre-report pa nga daw po sa ICC pag ipatawag sila, plus the voluntary conditions and promises na FPRRD na maging good boy na siya is a clear showing na hindi na po talaga daw siya or hindi po magiging flight risk talaga si FPRRD. Okay? And then yung next po, Mr. Duterte will not imperil proceedings if released. Ito yung number 2 dun sa paragraph B po ng Article 58.1, yung mag-intimidate siya ng witness, mag-evidence tampering siya. So dito again, ang sabi lang po dito ni Attorney Kaufman in summary is that an abstract analysis of the risk to contract or exercise pressure on potential witness does not pass Article 58.1b. Okay, the defense, even if it were to bear the burden of proof, cannot be obliged to prove a negative. This assessment must be based on relevant relevant and concrete evidence as opposed to abstract risks or conjecture. The onus is on the prosecution to demonstrate that Mr. Duterte would, and not just that he could, engage in witness intimidation or otherwise obstruct the conduct of the proceedings. So ang main argument po dito ni Attorney Kaufman, dapat daw mapakita na si FPRRD, there is a high chance for him na hindi lang niya posibleng mag-evidence tampering siya or mag-intimidation of a witness, pero ang kailangan po ipakita ay talagang gagawin daw niya yon, hindi lang posibleng gagawin niya. And dapat daw po that is going to be supported by concrete evidence. And again, the burden po is with the prosecution to establish that. So again, favorable to kay FPRRD because based on this lang po as a petition, hindi na daw mag-oppose diba yung prosecution. So more or less same po, kailangan hindi siya hypothetical, hindi lang siya an abstract analysis. It must be shown based on relevant and concrete evidence. And again, the burden is with the prosecution. So ibig sabihin po ng based on relevant pala dito sa legal system. When you say relevant is that yung evidence dapat must be related to the issue at hand, hindi po yung random lang na evidence na isubmit. Okay? And then next po ngayon, paragraph 27, prosecution has not cited recent and substantial security threats to witnesses or shown that these witnesses are facing a dire security situation. So this is actually, itong statement ni Attorney Kaufman na to, favorable to ngayon sa prosecution kasi ito lang pala yung kailangan ipakita ng mga prosecution, dapat ipakita nila or mag-submit sila ng evidence na may security risk sa witnesses. Pero at present, as per Attorney Kaufman, the prosecution has not shown na may substantial security threat to the witnesses. Therefore, showing na walang ginagawa si FPRRD at present to intimidate the witnesses. Okay? And then number 3, Mr. Duterte will not continue to commit crimes. So this one, ito yung ginagawang issue ngayon ng mga anti-FPRRD. Ginagawa nilang narrative na since ito daw yung ginamit ni Attorney Kaufman, therefore FPRRD committed crimes daw kasi he has made it incumbent upon himself that he will not continue to commit crimes. So masasabi ko lang po dyan, of course, ito inulit lang to ni Attorney Kaufman kasi yan po yung nakalagay sa Rome Statute were applicable to prevent the person from continuing with the commission of that crime. So para makorelate niya easily yung pinapag-usapan, inulit lang niya yung words nung batas. But it does not necessarily mean na FPRRD committed already a crime kasi tatandaan po natin, di ba, he is still an accused pa lang naman po. Nasa pre-trial pa nga lang po, he has not yet been convicted to have actually committed a crime daw, di ba? So this is just a terminology para pumasok po dun sa terms used or sa words used po nung Rome Statute itself. Pero yun, natatawa lang ako kasi ngayon ginagawang narrative. Pero anyway, ito po, skinip ko na, you can just read this kasi masyado na po tayong mahaba. Pero yung pinaka main point po dito is this one sa 32. It should not be forgotten that the crimes imputed to Mr. Duterte occurred between November 1, 2011 and 16 March 2019. More than 6 years have passed since the temporal scope of these crimes. The possibility of continuing with the commission of the crimes within the court's jurisdiction is highly abstract. Okay, so ibig sabihin po nitong highly abstract, in Tagalog, ang easiest way na ma-explain ko po to is parang is drawing lang daw na mataas yung chance na mag-continue ng commission ng crime. Okay? Highly abstract, highly unlikely, or in Tagalog pa, drawing lang yung chances na matutuloy to ni FPRRD. This because Mr. Duterte is no longer the president of the Philippines, does not command the same influence or power he is said to have abused during the period of the alleged crimes. He no longer holds the type of office that the prosecution argues allowed him to order and to implement the policies that form the basis for the ICC arrest warrant. Any risk is totally neutralized by virtue of Mr. Duterte's affirmation in the annex terms and conditions. Again, ito yung mga promises ni FPRRD na magiging good boy na siya, that he will refrain from public engagement, office, or communications with persons outside his family. He has also agreed to abstain from use of internet or any electronic devices such as mobile phone. Okay? So again, ulitin ko lang po, drawing lang daw or highly unlikely na magkakaroon ng continuation of a crime considering ang tagal na ng mga alleged crimes against him, more than 6 years have passed at hindi na po presidente si FPRRD ngayon. Therefore, he no longer has influence like what the prosecution or the complainants make it appear. And then, because also of the promises or the conditions set forth ni FPRRD na maging good boy na siya, any risk po of evidence, tampering, or witness pressuring, intimidation is totally neutralized daw po. Okay? And nagsabi nga rin po si FPRRD pala dun sa, sa condition set niya is that he will refrain from public engagement, office, or communications except dun sa family lang po niya. So talagang magiging legitimate na simpleng buhay, simpleng mamamayan na po si FPRRD once he will be granted interim release. Okay? So given these restrictions and considering he'll be residing well outside the geographic scope of the alleged crimes, the likelihood of Mr. Duterte posing a risk under Article 58(1)(b) 3 is non-existent. So yung medyo maganda po nating i-take note dito, or yung interesting po matitake note natin dito is this one, will be residing well outside the geographic scope. So does this mean po ba na malayo sa Pilipinas or well outside considering ibang bansa? So it's interesting kung ano po or kung saan po ba talaga yung bansa na mapupunta si FPRRD assuming mag-grant po yung interim release. Okay? Ngayon punta naman po tayo sa last na explanation ni Attorney Kaufman. So yung pinaka-last po nilang argument is yung humanitarian factors, okay, in relation to FPRRD's case. So this one has already been explained naman natin kung ano yung ground niya, diba? Because he's 80 years old, tas meron siya mga medical conditions. And then sabi lang din nila dito is that the ICC has in practice granted provisional release for humanitarian reasons. Number 50, may citation sila agad. So Bemba decision, there is a case. So ito pong case nito, kung makita nyo nga po, Mr. Jean Pierre Bemba's attendance of his father's funeral of his father. So although magkaiba silang situation, however, they are both or pwede sila both pumasok under humanitarian reasons. Kaya FPRRD lang dito due to his age and most likely health reasons. Hindi ko lang masabi na health reasons kasi puro redacted po, diba, dun sa mga paragraph sa taas. So dito po kung makikita natin, the defense submits that compelling humanitarian grounds exist. Mr. Duterte is 80 years old and blank blank blank. So ito mga sakit siguro to ng FPRRD, parang dami po ng sakit, puro redacted. So anyway, yan lang po yung discussion natin for the humanitarian factors. And then lastly po yung conclusion and relief sought. Kung makita po natin, Mr. Duterte does not meet any of the conditions to warrant further pretrial detention as provided in Article 58(1)(b). So of course, since wala na tong mga grounds na to under 58(1)(b), yung relief niyan is para makalaya siya or i-grant po itong petition for interim release. And then yung last po nilang request din dito na tinake note ko lang is the defense also respectfully requests that the deadline for any responses or observations be shortened in light of blank. So napapaisip na talaga ako. Kahit ako po gusto ko na makipag-marites kung ano talaga tong redacted na terms dito eh. So anyway, ito po yung point dito sa last is gusto nila paikliin yung periods due to this reason daw in light of this one. Okay? So yan po yung petition, yung buong petition proper po nila Attorney Kaufman. So Nicholas Kaufman, counsel for Rodrigo Roa Duterte, signed po niya dated this 12th day of June 2025 at blank blank. So secret nga rin kung nasan si Attorney Kaufman when he prepared this pleading. So I'm assuming baka nandun po siya sa receiving state when he did this. Okay? So ngayon magbigay lang po ako ng quick summary and personal observation ko po dito sa pinag-usapan po natin. So, for the quick summary po, tatandaan natin doon yung burden talaga to show na flight risk, may evidence, may risk for evidence tampering, witness intimidation, and the continuing of the crimes committed, the alleged crimes committed is with the burden is with the prosecution. So, yung maganda lang po dito sa petition na to or sa case na FPRRD ngayon is So yung maganda lang po sa case dito ni FPRRD is because the burden is with the prosecution nga. According to Attorney Kaufman, yun yung argument niya. That the burden is with the prosecution to establish that that FPRRD is number one, a flight risk, there is risk for evidence tampering, witness intimidation, and that there is a chance na makukontinue pa daw yung mga actions na ginagawa ng akusado in this case. However, since the prosecution has manifested, again, according to Attorney Kaufman, has manifested daw to him na hindi na mag-oppose sa petition na to. So pag ganyan po, mas favorable yun kay FPRRD, di ba? Because since the burden is with the prosecution tapos they will not oppose, therefore, hindi ma-establish yung mga allegations dun sa Article 58(1)(b). So kung hindi ma-establish yun, as per Attorney Kaufman, must be released daw yung isang akusado in that situation. Okay? And he also cited mga cases, di ba, kung saan na the ICC court has already granted interim release whenever the prosecution has not opposed po an application for interim release. So makita po nyo, sinite doon ni Attorney Kaufman yung mga legal basis nila, yung mga cases po na pinagbasihan nila ng argument. And ang masabi ko lang po, this is so far maganda po yung argument at kung magkatotoo po talaga na hindi mag-oppose yung prosecution dito, that will be very favorable po to FPRRD. And ayoko na lang po sabihin na sure na tayo na makakalaya si FPRRD kasi wala pa pong decision talaga yung pretrial chamber because at the end of the day, it is up to the pretrial chamber. I am simply giving po my professional assessment po of this pleading na finile based based on the arguments presented and statements manifested po by Attorney Kaufman. And lastly po, most likely the reason kung bakit hindi po nila nilagay dito kung anong bansa yung maging receiving state is baka po to avoid political pressure dun sa Prime Minister or sa President po ng bansang yon. Kasi alam naman natin, di ba, yung kaaway talaga ni FPRRD currently is the administration. So of course, the administration has all the resources, has all the influence, since sila po yung nakaupo dun. So baka ma-political pressure and it is most likely for that reason kung bakit nila ginawang confidential po yung mga certain mga bagay-bagay. Okay? So anyway, hanggang dyan lang po muna yung discussion natin for this one. So if you like more international law or ICC case videos po, madami na po akong ginawang mga videos tungkol dyan. So ilalagay ko na lang po yan dito sa gilid ng face ko para po pwede nyo panoorin kung magustuhan nyo. Okay? Hopefully klaro po yung discussion natin today. If you like legal educational videos sa current events, follow lang po kayo sa akin. Until next time, see you all po. Bye-bye!